This is part B of the three-part video on right to equality. In part A, I discussed Article 14 and 15. In this part, we now turn to Article 16, which takes the principle of equality and applies it specifically to the realm of public employment. This is where the rubber meets the road, where abstract principles translate into real opportunities for citizens to participate in the governance and the administration of their nation. Article 16 is about ensuring that all citizens have a fair chance to compete for jobs and promotions within the government. It's about creating a public service that reflects the diversity of our society and draws upon the talents of all its members. Article 16, Clause 1 lays down the fundamental principle. There shall be equality of opportunity for all citizens in the matter relating to employment or appointment to any office under the state. This means that every citizen, regardless of their background, should have an equal chance to be considered for government jobs. Article 16, Clause 2 reinforces this principle by explicitly prohibiting discrimination on the basis of religion, race, caste, sex, descent, place of birth, or residence. The use of the word only is crucial here. It means that these factors cannot be the sole basis for discrimination. However, as we'll see, residence can be a factor in certain limited circumstances. So, what does equality of opportunity actually mean in practice? It means that recruitment rules, promotion criteria, and conditions of service must be fair, reasonable, and non-discriminatory. It means that selection processes must be transparent and based on merit, not on arbitrary or irrelevant factors. Article 16 is just not about getting a job. It's also about career advancement. Once a person is employed by the government, they have the right to equal opportunity for promotion. This means that promotions must be based on fair and objective criteria, not on favoritism or bias. However, the concept of equality of opportunity is not absolute. The Constitution recognizes that some groups in society have historically been disadvantaged and may require special consideration to achieve true equality. Article 16, Clause 3 allows Parliament to make laws prescribing residence as a requirement for certain jobs in specific states. This is an exception to the general prohibition against discrimination based on the place of birth or residence. Article 16, Clause 4 empowers the state to make provisions for reservations in appointments or posts in favor of any backward class citizens, which, in the opinion of the state, is not adequately represented in the services under the state. This is the constitutional basis for reservation policies in India. Reservations are not, as some may think, a deviation from the principle of equality. They are a means to achieve substantive equality, a way to level the playing field for those who have historically been denied the opportunities due to their social, educational, or economic disadvantages. But the implementation of reservation policies has raised a number of thorny questions. What criteria should be used to identify backward classes? What is the permissible limit for reservations? How do we balance the need for social justice with the need for efficiency in public administration? And how do we ensure that the benefits of reservations reach those who truly need them? The courts have grappled with these questions for decades, shaping the legal landscape of reservations in India. Let's explore some key principles that have emerged. First, what is the scope and extent to which the affirmative action and reservation should be extended? It is well established that reservations cannot exceed 50% of the total available positions. This rule, first articulated in the Balaji case, aims to ensure that reservations do not unduly compromise the principle of equal opportunity for all citizens. While this limit has been challenged, it remains a cornerstone of reservation policies. In the Mandal Commission case, Indrasani versus Union of India, this limit was reaffirmed, although some exceptions may be permissible in extraordinary circumstances. Next, let us consider if all people in the identified group should be granted affirmative action. To guarantee just distribution, the courts have emphasized the creamy layer concept. This means that the economically advanced individuals or sections among backward classes should be excluded from benefits of reservation. The goal is to ensure that the benefits of affirmative action reach the most deserving members of the backward classes. This helps prevent elite capture and ensures that resources are directed to those who need them the most. And finally, it is important to remember that reservations is not the only requirement to be met. It is well settled and understood that the group benefiting from affirmative action and the reservations must still come up to a minimum level of capacity and skill to complete the services that they are selected for. Thus, it is critical to balance representation of disadvantaged groups and the needs of the economy. These key principles and many others have emerged from a long line of judicial pronouncements, including landmark cases of M.R. Balaji versus State of Mysore, Indra Sahni versus Union of India, Ashok Kumar Thakur versus Union of India. Each of these cases have contributed to our understanding of the scope and limitations of reservation policies. These cases continue to be studied and applied to our modern understanding of affirmative action to promote equality in the workplace. It is very crucial for all of us to be intimately familiar with this body of law. Understanding the nuances of reservations jurisprudence is essential for promoting social justice and ensuring that the promise of equality in public employment becomes a reality. Now, let us delve a little deeper into the cases and how it affected the jurisprudence of reservations in India. In the infancy of the Indian Republic, as the Constitution's promise of equality echoed through the newly formed nation, the courts began the delicate task of shaping Article 16, the guardian of equal opportunity in public employment. This period from 1951 to 1975 was a time of laying down fundamental principles of understanding the very essence of what equality meant in a society marked by deep-rooted disparities. Our narrative begins in 1951 with Venkataramana versus State of Madras. Imagine the courts, like young scholars grappling with the concepts of backward classes. This wasn't a merely legal term. It represented a social reality, a historical burden carried by many. The judges in this early phase sought to delineate who among the vast diversity of Indian society deserved the protective mantle of Article 16, Clause 4. They began the arduous process of translating social realities into legal definitions, a process that would evolve over decades. The jurisprudence here was one of initial definition, a first attempt to categorize and understand. Then, in 1962, in the case of M.R. Balaji versus State of Mysore, the courts, now more confident, sought to establish a framework for practical application of Article 16. The introduction of the 50% ceiling wasn't arbitrary. It was a judicial attempt to reconcile the competing demands of affirmative action and the broader principle of equality. The judges sought to construct a system where both principles could coexist, where the upliftment of the marginalized didn't come at the expense of the larger ideal of equal opportunity. This case established a jurisprudence of balance, a recognition that equality was not a zero sum game. By 1964, in T. Devadasan versus Union of India, the courts turned their attention to the mechanics of reservation. The carry forward rule, a seemingly innocuous provision, was scrutinized. The judges, ever mindful of the potential for abuse, ensured that this rule didn't become a tool for disproportionate reservation, thereby safeguarding the 50% ceiling. This was a jurisprudence of procedural fairness, a recognition that even well intentioned mechanisms need checks and balances. Finally, in 1975, with the state of Kerala versus N.M. Thomas, the courts began to articulate a more nuanced understanding of equality. They recognized that formal equality, treating everyone the same, often fell short of achieving substantive equality, where historical disadvantages were addressed. The relaxation of qualifying criteria for SC/ST candidates was not seen as a deviation from equality, but as a means to achieve it. This case represented a shift towards the jurisprudence of substantive equality, a recognition that equality was not merely a matter of treating everyone the same, but of ensuring that everyone had a fair chance to succeed. These early cases, like the initial chapters of a grand legal epic, were instrumental in shaping the jurisprudence of Article 16. They were the foundation upon which the courts would build a more robust and nuanced understanding of equal opportunity, a foundation that would be tested and refined in the decades to come. Between 1992 and 2018, a period marked by intense national debate and significant judicial pronouncements. This era wasn't about interpreting legal text. It was about grappling with the very fabric of Indian society, addressing historical injustices, and defining the boundaries of affirmative action. In 1992, with the landmark case of Indira Sahani versus Union of India, the Mandal Commission case, the nation was divided as the government decision to implement the Mandal Commission's recommendation, providing 27% of reservations for other backward classes in government jobs, ignited widespread controversy. The courts, faced with this societal upheaval, had to navigate a complex terrain. They upheld the OBC reservations, acknowledging the social and educational backwardness that persisted in Indian society. But they also introduced the concept of the creamy layer. Now we come to the case of Ajit Singh versus State of Punjab. The case dealt with the catch-up rule and the consequential seniority in promotions, issues that directly impacted the career trajectories of government servants. The courts in this judgment clarified that while promotion itself wasn't a fundamental right, the right to be considered for promotion was. This was a jurisprudence of procedural fairness, ensuring that every eligible employee had a fair chance to advance in their career. Now we come to the M. Nagaraj versus Union of India case. In this case, the validity of the amendments that allowed reservations in promotion for scheduled castes and scheduled tribes were discussed. The court in this crucial case upheld these amendments, acknowledging the continued need for affirmative action at higher levels of public employment. However, they also set stringent conditions. The government had to demonstrate the backwardness and inadequate representation of these communities with quantifiable data. And the creamy layer principle was also applied to promotions for SCs and STs. And this was the jurisprudence of conditional affirmative action, balancing the need for representation with the imperative of administrative efficiency. Finally, in 2018, the narrative continued with Jarnail Singh versus Lakshmi Narayan Gupta. The courts in this case refined the Nagaraj ruling, acknowledging the historical backwardness of SCs and STs. They held that the government didn't need to provide fresh quantifiable data on their backwardness for promotions, but still had to demonstrate inadequate representation. The creamy layer exclusion for promotions remained. This was a jurisprudence of refined application, building on previous precedents to ensure a more nuanced and practical approach to affirmative action. This pivotal period, from 1992 to 2018, was a time of intense judicial scrutiny and significant legal developments. The court skillfully shaped the jurisprudence of Article 16, balancing competing interests and striving to create a society where equality of opportunity was not just a legal principle but a reality. The story of Article 16 entered a new phase in 2021. As the courts continue to grapple with the evolving landscape of equal opportunity in India, this period, marked by a series of significant pronouncements, reflected the judiciary's ongoing commitment to balancing affirmative action with the fundamental principles of equality. In the case of Janhit Abhiyan versus Union of India, the court debated the validity of the 103rd Constitutional Amendment. The core issue was the introduction of 10% reservation for economically weaker sections. The Supreme Court in this landmark judgment upheld the amendment, expanding the scope of affirmative action beyond traditional social categories. This was a jurisprudence of evolving inclusivity, recognizing that economic disadvantage could also be a valid ground for affirmative action. This case added a new dimension to the equality that Article 16 seeks to protect. In the year 2024, there were a flurry of cases, each case adding a new layer to the evolving jurisprudence of Article 16. First, we have the state of Punjab versus Devender Singh. The court in this case debated the intricacies of subclassification within scheduled castes and scheduled tribes. The Supreme Court in this chapter upheld the validity of subclassification, allowing for a more targeted approach to affirmative action. This was a jurisprudence of refined targeting, acknowledging that even within the historically marginalized groups, some faced greater disadvantage than others. However, in Gaurav Kumar versus State of Bihar, the Patna High Court reaffirmed the enduring importance of the 50% reservation ceiling. As the Bihar government's attempt to increase reservations beyond this limit was challenged, the court in this case struck down that increase, upholding the principle of balanced representation. Meanwhile, in Samata Vaman Rao Varutkar versus State of Maharashtra, the Bombay High Court addressed the issue of fraudulent caste certificates as the integrity of reservation system was challenged. The court in this case refused to protect admissions obtained through fraudulent means, sending a strong message against the misuse of affirmative action. This was a strong example set for those people who had fake certificates of SCs and STs just to take advantage of the opportunities that were actually available only for the SCs and STs. Now we come to the case of Ravi Kumar versus Dhanshuk Lal Mehta versus the High Court of Gujarat. The Supreme Court upheld the Gujarat High Court's promotion process for district judges, affirming its compliance with the merit cum seniority principle under Article 16. The petitioners argued that seniority was wrongly prioritized over merit, but the court ruled that promotions were granted based on merit first, with seniority considered among qualified candidates. This judgment reaffirmed fair and merit based judicial promotions. And now we come to the recent case of S. Ramanayya versus State of Andhra Pradesh. S. Ramanayya had been working as a contract employee for years, performing the same duties as the regular staff. Despite vacancies in the department, he was denied equal pay and job security. Frustrated, he took his fight to the court, arguing that he deserved fair treatment under Article 16 of the Constitution. The Andhra Pradesh High Court agreed. It ruled that contractual workers doing the same work as permanent employees should not be treated unfairly or unequally. The court ordered the state to ensure fair consideration, marking a victory for employment equality. These recent developments demonstrate the judiciary's continued commitment to refining and applying Article 16 in a dynamic and ever changing society. This is part B of the video on right to equality. The part C will be coming out soon. I hope you have seen the part A as well. Thank you for watching and helping me boost your legal IQ.